Good evening, ladies and gentlemen. Thank you so much for joining us for tonight's edition of HR Mentorship Learning Series. I'm excited to have us join this live session. Tonight, we'll be looking at a topic, digital responsibility beyond the screen, legal and HR insights for the workplace. My name is Oluyemi Abiosho, and tonight we have two facilitators collaborating to deliver this world-class session. And I will read the profile of our two facilitators in quick succession. Ladies and gentlemen, our first facilitator is one of our core admin members here on HR Mentorship. She's Abimbola Victoria Akindilete by name. She's a strategic HR and admin leader with over 12 years of experience across the legal, oil and gas, healthcare, and consulting sectors. She currently heads the HR and administrative function at one of Nigeria's foremost boutique law firms. She holds a Bachelor's of Arts Education and a Master's of Arts in English, and she's currently pursuing her MBA. Abimbola is SPHRI certified and associate of the Chartered Institute of Personnel Management of Nigeria, ACIPM. She is also a certified management consultant, and among other things, she's the founder of Recruit Aid Business Advisory. Abimbola is passionate about building structure, systems, and strategic impact in HR, driving people performance, and also stakeholder value. Ladies and gentlemen, joining her tonight to co-facilitate this very session that promises to be insightful is Barrister Miriam Oyede. She is an associate in the Dispute Resolution Practice Group of Wole Olanipepo, where she advises on complex litigation and corporate commercial matters, tax and fiscal policy, and real estate law. Miriam has participated in high-value disputes and advised on regulatory compliance across sectors such as information communication technology, financial services, property development, and government revenue. Our work increasingly intersects with technology and innovation in law. She authored a detailed analysis of the 2024 Federal High Court Practice Direction on affidavit, co-authored an expose on the revised Supreme Court rules and currently reviewing the new tax laws. She has two published exposés on the NRSE Act, JRBE Act. She also Hello, Miriam.
Hello, Sam, it's you.
Hello, Miriam.
She said her network went off, that she will soon be here
Hello,
now.
Miriam. Hello, Miriam. Miriam, are you on the call? Please. You please start the session. You please start the
I'll
session.
join
The
us
recording has
soon.
been.
Hello, Sam, yeah.
Please, can you start the session? Please. Can you start the session? Please. Share your screen and start the session.
Okay, that's fine.
Network will not allow her back. Please. There's no time.
Okay. Please confirm that you can see my screen.
Yes, I can see it, even though it's not full screen yet.
Okay. Good evening, everyone. My name is Miriam Oyede. Is it better now, sir?
Yes, you can go on, please.
Okay. My name is Miriam Oyede. First, I would thank everybody for joining us for today's session on digital responsibility beyond the screen. I shall be presenting the legal insights for the workplace. So basically, as our work culture becomes increasingly digitized, our responsibilities extend beyond simply knowing how to use the technology, but also knowing the policies that guide this technology. I mean, HR was supposed to start, so she will give the HR insights, but her network went off, so I'll just proceed with the legal parts. So before I proceed, we'll just talk about the fact that technology has long been a part of our workplace. It has a lot of recent innovations from AI-powered recruitment platforms to us storing our communication tools in cloud, and also how we interact with our clients. So most tier one firms or most tier one companies now rely on technology for core HR functions. So in the middle of all of this, how do we regulate our actions as HR? How do we regulate our actions as a person? So for example, for recruitment, HR tends to like upload CVs on websites for algorithms to match the skills of that person with the skills that is needed in the for the job. So at times these things have their own risk. In fact, most times these things have their own risks, but they are not things that we cannot manage. So as we progress, we'll look at the risk we have and the colors. So before we proceed, I would like to give some real world scenarios where data risk has actually has done more harm than good. So before we delve into the extant regulations for digital responsibility, let's just examine the risk in real world scenarios when data was put at risk, this was what happened and all of that. So the first one we'll consider is Cisco. I believe we all know Cisco is a provider of security systems. They are a traffic director. They move data between devices. So of course they deal with personal data and confidential information. So in May 2022, one of their employee, they reported, although yeah, there was the news, so they now reported on their official website that one of their employees fell victim of a phishing attack. Phishing attack is voice phishing, more like a voice call when you use fraudulent phone calls to trick victims into divulging information that they should not divulge. Like it would be like an internal call, but it was external. So the company reported that the actor was able to access and export a subset of information like login credentials, a subset of information from one. So they have a third party company where they work with. So it was through the third party that they got that information. But Cisco reported that they didn't actually get customers information, that it was just basic profile information. So the question here is where what if the situation had escalated and they could not interrupt or stop the and those things could have been compromised. Another instance is Yum Brands. That's Yum Brands. So Yum Brands in January 2023, just a few months after the Cisco incident, January 2023, which is a US fast food corporation. It owns companies, it owns franchising companies like KFC, Pizza Hut, Taco Bell, to mention very few. So in 2023, they also suffered a data breach. That's when an external party comes in, takes your data, holds it hostage, then asks you for money. That's ransom. Is asking you for a ransom to release your data, to leak you, to just delete it and clear it off. So you have to pay. So Young Brands also reported that the what is it called? The ransomware attack did not actually affect customers' data, but it affected their employees' data. So those that were affected were actually notified that they were notified and things just got escalated. So eventually, during the attack, Young Brands had to close like 300 outlets of their businesses, which of course is a very, very which has its own financial implications. So I will ask again, what if the situation was worse or if the attack was not discovered immediately? So bringing it home, we remember that there was a time we were more like informally notified about operations, and that we should be cautious while dealing with POS terminal operators because they take our card details, and some of them even go as far as taking snapshots of the front and back of our cards. Some of the risks of and it shows the risk of exposing us the consequences of digital irresponsibility. So where we don't have we put our clients or us or our customers or even the company at a lot of risk. Some of them are highlighted on our screen. So we have identity theft and fraud. Identity theft is when somebody else is acting as you, basically impersonation, and the person could get benefits, mostly illegal benefits that you were ought to have gotten, or just use your information to derive information or even money from people that you know. So the person is acting as you. Another one is privacy violation. I mean, if we are not digitally responsible, our client's privacy or our customers' privacy or even the company's privacy will be violated. It will be out in the open, and we will just lose trust. Our customers will lose trust in us. So the next one is true phishing or phishing. I think we already spoke about that. So the third party is just simply means that, okay, you violated somebody's privacy. That person violated the person's privacy, that's vulnerable for people to go into. I will definitely want to trust them with my confidential data. For a company that deals with password, confidential information, and transferring data from one system to the other. And another one is the next one is because we have laws that regulate our data, and we have this law on releasing the data out. I mean, when all of this happen, when the privacy is violated, or when identity theft occurs, we have laws that regulate these things, and these laws might impose fine on the attackers. In fact, that's even where you get the attacker. It might impose fine on the persons, on the data controller or the data protector, the person in charge of the data at that moment, the person that hosts the data at that moment. So the next one is operational disruption. If you remember that Young Brands had to close down like 300 outlets, which of course led to financial implications for them. So now that we already know the consequences of digital irresponsibility, let's proceed to the core legal frameworks that we have. So in Nigeria, the major backbone of digital responsibility is the Cyber Crimes Act. So Nigerian Cybercrime Prohibition Prevention Act. And we have the Nigeria Data Protection Act. And so the Nigeria Data Protection Act, as the name implies, protects our data. Especially it imposes a lot of responsibility, liabilities on data controllers who have information of data subjects. So the Nigerian cybercrime criminalizes and regulates a lot of technology and client misconduct. Let's look at some of the key sections rather. So we have section 6 that talks about unauthorized access. It says that our employees must not have unauthorized access to systems of must not have access to files or systems without it talks about system interference is harassment, because when someone's privacy is already out in the open, the person is cyberstalk, people call cyberbullying. So digital harassment, threats of offensive content via work channels is a criminal offense. So, well, in fact, the and another one is electronic communications misuse. So for electronic
I think network has taken her out. Vicky, you can please attempt to unmute and speak. You are not a co-host. Even me, I've been facing serious network challenges today, so I understand completely. But I think Miriam is back.
She's back. Even me, I'm currently in the car now. I'm just still trying to look for network everywhere.
All right. Miriam, we didn't hear you the last few minutes, so you can like go back 1 or 2 slides so that we can hear you now. Network was full of
okay, let me try to share
you.
my screen. Sorry for the interruption. Yeah, so please confirm you can all see my screen.
We can see your
Yes, we
screen.
can.
Okay, thank you, ma'am. So you said I should go a few slides back.
Maybe 1 or
More
2.
like here.
It's okay.
Or should I just start the legal framework again? Because I'm trying to know where I stopped. Because of time, especially.
Okay.
1 or 2 slides backward is good.
Okay, Miriam, can you hear me?
Yes, I can hear you, ma'am.
Okay, I think since I'm back now, because it's important that I take the HR framework before you take the legal framework.
Exactly.
Can I just probably start my own screen so that I can quickly just share the HR framework, then you go over your legal framework again?
Okay, that's fine. So I won't have to talk about the risk anymore since we've talked about it.
Okay, that's fine.
Thank you.
Please confirm that you can see my screen.
Yes, it's up.
Okay, so I'm so sorry for this. I am supposed to start first, but network took me out. I was trying to networks that I have before I get through to this one. And well, I'm just hoping that I'm able to take this. Okay, so introduce us to the topic. And have about 3 to 4 nuggets before I go HR framework. Pardon the noises you might be hearing, because I'm currently in the compound network and there's a swimming pool nearby in our compound. So that's the noise you're hearing. Noise. So in today's world, your digital footprint speaks louder than your resume. And I believe because the and with we see, that is your digital footprint. Dr. Vinton, that is the co-inventor of internet, mentioned that internet is written in ink and not in pencil, not with pencil. And so whatever you share lives on, even after you forget it. Sometimes even after you deleted it, it still lives on because people might have screenshotted it, blogs might have carried it, and so it continues to get circulated even after it has been deleted. And so that's why it is said that the internet is written in ink and not in pencil. Your visiting post, whatever it is, what you post online or you send to a person or you said about a person, it speaks more about you than your words in person. Digital decency is real world integrity. So what are we saying there? So when you say someone, it is you post it, it speaks more about you than and you're talking about or whatever it is the person that might have done. For example, hearing me.
Yes, ma'am, we can hear you, but it's breaking.
Okay, so let me quickly use an example. Recently we got news online that Toke Makinwa got pregnant, and a lot of people were happy for her, trooping to her page, were congratulating her and all. And then there was a particular lady that posted under that post where she showed a baby bump, saying that why do I think that this is I think she said, why do I think that this is a facade or make believe or something like that? That why is she think that why do I think that this is a facade and it's just probably she working on surrogacy or something like that. The way she said it was so bad. And she actually used her business page to post that on that Toke Makinwa's baby bump post. A lot of people were so mad at her that why would you as a woman post this? Surrogacy or no surrogacy, we all know what this lady has been through in marriage and all about pregnancy, and she's finally pregnant. And you're saying all of this. A lot of people were saying a lot of things. Now, it does not end there. People trooped into her page. They saw that it was a business page, a company or a firm or a business that sells perfume. And they started commenting under the businesses. I'm sure this is not the first time we'll be seeing a lot of this. A mistake or probably just a mistype that boomerang. And that lady had to change her name, the name of her page, to a name that does not have anything to do with herself. She had to take down her own face from her page because people were commenting on every picture that shows her face. She had to take her face down. She had to take everything that people can use in relating that pic to her down. And people still continue to comment. At a point, she had to remove, the comment section so that people will not be able to comment on her page. What am I saying? I'm saying that you can see from there that just something that this person said about one particular person has backfired on her. So we're saying that whatever it is you have said, how do audience perceive what you have said? It stays as a public record. And whatever it is you have said, even if you're coming back to say, oh, that is not what I meant, I was just saying that, what the first thing that audience perceive is your immediate intent when it comes to audience. And that is what tells us if you are digitally decent or you are not digitally decent. Being in HR doesn't excuse bad digital behavior. In fact, it requires us to do better. HR isn't just about enforcing culture. HR is culture in itself, both online and offline. We are like the ambassador of our organization, and we are also supposed to build this culture in our employees, in employees to also do the same. We are supposed to lead by example. We are supposed to, set clear digital policies. We're supposed to continue to train employees to do better online and offline. That way it does not bring back a stain or a taint to the business name or the company's name. So what exactly is digital responsibility? I'm sure that my colleague Miriam must have defined what digital responsibility means. It's just very simple. Just being digitally responsible, being digitally decent, watching what you say online, watching what you post. Be very careful before you say things out there or before you put anything out there, before you screenshot what somebody had told you in the DM and post it somewhere. Just think about it. This thing I'm about to post, if people see it, what exactly are they going to say? Regardless of where you are posting it to, even if it is HR group or wherever it is you are posting it to, it is more than policy. It is your intentional behavior. It spans your values, your ethics, and your digital decency. So I'm trying to be fast because of the network. Now, what exactly is irresponsible digital behavior? I will just mention the few that we are seeing here. I would also enjoin us to probably drop in the chat button some of the irresponsible digital behavior that you may have noticed online, offline, that spans to what we are talking about. Oversharing personal data, spreading misinformation, cyberbullying others, ignoring privacy settings. It's a whole lot, you don't seek consent before posting people's numbers out there because you have access to people's contacts. Oh, somebody asks you, oh, I need somebody to be able to do this. Oh, I want to gain access to so place. And because you know somebody who actually in that place, you did not even bother to seek consent from that person. If it is okay for the person to talk to this person that is seeking help, you just blow everything out there. You share the person's phone number, you share the person's email, you even post it on the group. Or you even screenshot chats of discussions with you and somebody. You just post it out there without caring if this person is going to like it. Digital decency spans across even the little things that we often overlook. Something as simple as just picking your phone and calling someone that you're not probably accustomed with, or you're not probably used to, or you and the person does not have a close rapport, and because you have the person's number, maybe you and the person is in the same association or the same group, you just pick your phone and you dial the person's number and you call the person. Some people will even call once, they will call twice, they will call thrice, they will continue to call until you pick. Some people will call at ungodly hours. All of these little things that we feel, oh, it doesn't matter. It's not, life is not that hard. All of these things spans, boils down on what we call being digitally decent. Now, I also know that there are sometimes that because of the issues at hand, we might be very quick to have done some things that are not exactly digitally decent before we think through it. It also boils down on how do we take feedback when this is brought to our notice that, oh, this was not digitally decent. How do we also take the feedback? So what are the risks and impacts when it comes to digital indecence? You cause emotional harm to the person. There is broken trust and psychological distress. There is reputational damage in some cases, harm to personal or organizational image, productivity loss, legal breaches, and a whole lot of things like that. Just one digital indecent behavior can cause an irreparable damage that you would not be able to, process it or get yourself out of it on time. If you're familiar with LinkedIn, you would know a whole lot of this thing, or Twitter. You will hear a whole lot of this. There was a time that we heard about a story of two HRs in the DM having those occasions. One is a senior and one is a junior, and then the senior, person threatening the junior person and all, and the junior person, oh, you threatening me, screenshotted it, sent to the friend, oh, this old senior person in so association is threatening you, put it on LinkedIn and all. It led to the senior person having to delete his LinkedIn account and a whole lot of things like that. We will get to the part where we treat scenarios of examples of these issues, things like this that has happened in the past, and how it has affected the individual or the organization. HR's role in digital responsibility. It is our job to shape digital culture, to set the tone for respect, safety, and ethics. Let me use myself as an example. For example, in my organization, for example, apart from every other avenues where we meet each other, we also use WhatsApp, to be able to get close to each other, communicate, timely communication, both during work hours or after work hours. I do not just leave that WhatsApp for people to just communicate or drop anything that is not work related. I ensure that I monitor the WhatsApp to ensure that whatever it is we are posting is either work related, or even if it is playful or we're playing with each other, anything we are posting must be decent enough to not cause harm. There must not be anyone that is feeling choked or not feeling exactly okay with the particular information. If I see that there is somebody that has dropped a particular information, which I see that this is a breach of data privacy, if it is with internal communication, I quickly reach out to the person that, can you confirm that you have the permission of this person to share this information? If the person is not able to confirm that, I go in and take it down immediately. If you're posting something that is not work related, maybe scandalous or something that is not work related, that people can get easily uncomfortable, I take it down immediately. So it is our job to ensure that we continue to set digital culture, set the tone of respect, ensure that everybody is safe, and ensure that there are the ethics of the organization is maintained. Someone is raising his or her hands up. Please, can we please unmute the person? Maybe the person want to speak to this particular bullet point, HR's role in digital responsibility, or the one I asked before, which was the indecent digital behavior that we have noticed in the course of our work. But if you can wait, we are still going to probably discuss very well when we get to the case study session, where you will see a lot of case study that I brought out from this. So let's quickly move to the next slide. Bloodlines, work and personal digital life. So when it comes to digital decency, I put in each person under 3 subheadings, or what I call persona. As a person, online, on a social media, digitally, while using any digital tools, especially as an HR, you're there as a professional person. You are there as a professional, and you are bound by the ethics of whatever profession that you have. Now, since this is an HR webinar, you know that you are bound by the HR policies and ethics. And your responsibility there is to ensure that your workplace conduct, both online and offline, is maintained. Even when you are not at work, you want to make sure that you're not saying something that they will trace back at, oh, this person works here. Imagine, how can somebody that works in so place be saying this kind of thing online? You want to ensure that whatever it is you're doing or you're saying, whatever it is you are putting out there, whatever it is that represents who you are, it's also something that represents who you are professionally. So that is the first persona. You are a professional. Now you are a citizen. As a citizen, you are bound by civic responsibilities. And under, one of your civic responsibility is, that you have to ensure that you're not circulating fake news, you're being respectful during discourse, you are not bullying anyone, you're not threatening anyone, you're not putting anyone in a fix where the person feels unsafe with whatever it is you're saying to them, whatever it is you're sharing with them. That's your second persona. And then your third persona is you are a human being. Now, as a human being, let's leave your profession out of it. Let's leave your being a citizen out of it. You are also bound by your conscience and empathy. So you are supposed to have some dignity, which you're supposed to protect. You are supposed to be kind. You are supposed to ensure that whoever it is you're communicating with feels emotionally safe with whatever it is you're passing out there. And it is very important that all of these three personas, you ensure that you are taking note of these three personas in whatever it is you do digitally. It is very important, because when you do this, you will be able to, can you still hear me?
You can hear you, Ma.
Okay. So when you do all of this, you're minding the fact that as I am, whatever it is I say out there, for example, I am on Instablog, I am on Instagram, I am on Twitter, I am on LinkedIn, whatever it is I'm saying here, I am a professional, I'm an HR professional. I have a responsibility. I am bound by HR policies and ethics.
Yes, we can.
Now I am a citizen. I am bound by civic responsibility in whatever country that I find myself or state I find myself. I'm a human being. I have conscience. And I'm supposed to be empathetic towards my fellow human beings. So these three personas are very important. And they help us to be able to, to maintain what we say, what we do, and how we do what we do online. And also how we help our employees, how we coach them, how we train them to be able to do better online and offline. And all of these things that we are saying boils down on one thing, and that is our organization, our branding. That's our employer branding. All of these things that we are saying is under our employer branding. Because whatever it is we say out there, let me use myself as an example, or let me use my colleague, for example. She works in my organization. We both work together in the same organization, which is a legal sector, and she is a lawyer. She's bound by ethics of her profession. She's bound by the code of conduct of our organization. She's also bound by some civic responsibility as, as a citizen. And she's also a human being, which of course she has conscience and all. She can't just go online now and say some things and just, the first thing they will say, they say she's a lawyer. They say she even works here. Imagine. Is this what they recruit in that organization, this kind of lawyers? Just imagine one person is doing whatever it is she likes out there. She probably is not even doing it with our organization's account or anything, but she will be traced back to us. And so whatever it is they are saying to her as they are giving her one, they are giving us too in the organization. And so this is why it is very important. It is not something that you as an HR, we just look at and we just say, well, this thing could matter, and you just take your eyes off it. It really matters. It boils down on your organization, your employer branding. So let's quickly look at a lot of some case studies, which I believe that this is the part that we get to share our mind and we get to talk. Case study 1. During, please, if you cannot see my screen very well, you can just let me know in the chat button so I can probably zoom in better. So, but I'm going to read it out. Internal chat violation. During a team discussion on a company's internal messaging platform, probably Slack, Teams, or WhatsApp, a staff member takes a screenshot of the chat, possibly including sensitive conversations, decisions, or colleague remarks. Without any consent, they share that the organization or team, either in another group or social media or with external contacts. The content circulates, causing reputational damage, discomfort among colleagues, and a breach of internal trust casually, without realizing the harm it causes. Sometimes it is done out of excitement, curiosity, or even as a harmless update, but the impact can be long-lasting, especially when names, opinions, or strategies are exposed. In many cases, the original sharer cannot be traced, but the consequences remain. This is a reminder for all of us. Just because something is visible to you doesn't mean it is yours to share. Let's hold ourselves and each other to the higher standards of digital discretion and decency. What are we saying here? Probably we are in, it's a group, an organizational group and all, and then there is a conversation that is going on in there. For example, maybe civil, let's use the civil, public, public organization as an example. Maybe 2 civil servants in their groups, maybe they were just talking, they were just having conversations. Maybe 2 public school teachers, for example, they were having conversations in their office WhatsApp group, and they are probably talking about a particular child, a particular student of the school that is probably very stubborn. And they were talking about it. This boy is very stubborn. He did this to me yesterday. I had to beat him. I had to train him very well. You don't do things like that. I don't know who raised, Now, there are 2 issues there. These people are saying all of these things using a digital tool. People are looking at them. People are here, reading what they're saying. But they felt that it is an organizational group. They felt they feel safe. Maybe it is even all the teachers in that public school that were even talking about a particular stubborn kid. And then there is one particular staff who probably screenshotted this and sent it to the parents of this child. Just imagine what is going to happen. Because you know that this parent is not going to take it kindly with the whole of the school. The parents, if in this digital world, might even post it out there, post the screenshot that was sent to her out there. Oh, see what, let's say, so grammar school was saying about my child. And then the whole, grammar school will be dragged, and even the government, the state government, the Ministry of Education of that party, everybody is going to get dragged because somebody was digitally indecent. Now let's look at another one. External overshare. A recruiter HR group and clearly requests that referrals be sent via direct message. I'm sure most of us have witnessed this. We've experienced this in one way or the other. Without permission, another HR colleague shares the recruiter's phone number elsewhere in a different group or another platform, encouraging job seekers to contact the recruiter directly. Soon, the recruiter starts receiving unsolicited calls and messages at odd hours. The outreach is chaotic, confusing, and completely outside what was requested. Trying to regain control, the recruiter came back to the group and says, please stop sharing my number. I only ask for referrals via DM. This is really getting uncomfortable. But instead of support, the fellow HRs or recruiters, they were dismissive and they started laughing. Responses like, oh, you're just overthinking this. Oh, you're just overreacting. You should have expected this when you posted this in the group now. You should have probably, some people will say you should have given your email address. It's because when you did not give your email address, what were you expecting? You thought it's not that serious. You're just overreacting. Calm down. Or worse, you should have just created a Google form. Now see what you are facing. Now the recruiter is not only overwhelmed by what had happened, but is also like overwhelmed by the responses he or she is getting. Their own privacy has been breached, and people who did it saw nothing wrong about it. Now this moment becomes a mirror. I'm very sure that most of us must have seen this happen in groups that we belong to. As HR professionals, how are we protecting each other digitally? Not just the employees we serve. Because if we cannot protect each other, your fellow HRs, you cannot even protect them digitally. How do you claim to protect the workforce? How do you claim to protect the organization that you work for when you could not even protect your own fellow HRs or your colleagues? How do you then say that you can protect your workforce? All of these little things matters. Let's look at another case study 2. Somebody maybe in a group, they were socializing and they were gisting, or probably they were being asked to introduce themselves. And let's say HRA posted a video of herself, dancing and just making sure that the group comes alive. And people were laughing and smiling about it. And some people were even saying, oh, I love your office. Your office is nice. Oh, I love your outfit. And somebody screenshotted this and sent it to an acquaintance, or probably was the person's colleague, or was their boss. Now, the boss is probably somebody who is overly strict. This HR is under fire. You are dancing during work hours, or some other even more serious issues. The HR felt that, or this person felt he was communicating in a group where HRs who are supposed to be digitally decent, but the reverse was the case. Now, this isn't a social media issue. This is a personal and workplace ethics issue. If someone shares something in a trusted space, Why do you think you have the right? Because you have access to that information, then you pick it up and then you turn it into a gossip thing or something to be shared without approval of the person who owns the right, who has the right to that information that you're sharing. The person probably shared because he or she felt, I'm in a safe space. I am in a group, or I'm in an association, I'm in an event where fellow colleagues are. But the person has met the shock of his or her life. Now the person is going to be reserved, is going to be very careful in sharing information in the future because there is no digital integrity, because there is no digital decency. We must normalize consent and confidentiality. It is very important. Even in informal settings, it is not a yardstick that, after all, we are not in the workplace. Be in a professional person. Whatever it is we do, sometimes even in our bedroom, we have to be cautious of the fact that we carry a name that must not be stained. And when we do make mistakes, we have to be, because we are human, you know, we have to be human and decent enough to be professional. We have to be professional enough to apologize without trivializing the harm. You know, something like, it is not serious. It's not that serious. This life is not as serious as you are thinking it. Calm down. We should learn how to not trivialize that issue. The last case study, oversharing in the name of help. This actually happened in a group that I was. Now, an employee was in distress. Something was happening with this employee. He didn't know how to go about it. And he called his friend who is an HR. My friend, please, I'm having this issue and this issue. Can you advise me? How do I go about it? Now the friend was like, this is serious. So I'm coming. Let me quickly seek help, or let me quickly seek advice from my colleague, my HR colleagues. The person came to the group and shared this information. Oh, fellow HRs, my friend, a friend of mine is in distress and all. The mistake the person made, this is where the digital indecency started, or the digital irresponsibility started. Now, the person shared this information with the full name of the organization, the details of the personalities involved, and every information that could be used to trace that story back to where it came from. The person posted it in the group. Please, I need help. You know, while everybody was already asking, giving information that, oh, do it like this, or do it like, a lot of people were even already, castigating the organization and all. But what I saw was not the problem that they are already giving solution to. What I saw was an employee that is at the verge of losing her job. His or her job, because I'm looking at the information of this organization out there, and this is a known organization. So I immediately, reach out to this person that you have to take this down. This is wrong. They could trace this organization, the name is out there. They could trace this your friend. Please repost this thing and remove this person's name and all. So it is not a group that I am an admin of. Maybe I would have helped the person to delete the post as it comes. That is one of the things that we do in HR mentorship. Sometimes that we use in saving you that is posting them, making this post. We immediately delete it. You probably might think that, oh, this admin they are being rigid. No, we are trying to be, help you with digital responsibilities that you probably might have omitted. So because it is not a group that I am an admin, there was nothing I could do than to advise this person. But the problem is that before this person could come online to see my advice on the DM and in the group, somebody had already screenshotted this message and posted it to, sent it to the HR of this organization. And they immediately called the employee because, of course, it was easy to trace the department, everything was out there. So they immediately called the employee. The employee, went into, started querying the employee and all. In fact, I had even forgotten about the situation, not until later in the day when the person came back and said, thank you for the advice. So unfortunately, I wasn't able to see it on time. This exactly what you said happened. Somebody posted it and sent it to the HR. Now I'm seeing two issues. When you see that somebody posted something like that as an HR, now shouldn't you have known that this person is probably an HR that is still up and coming, that still needs grooming, that probably do not understand much about digital responsibility and how to, to be discreet while asking for help? Shouldn't we be digitally decent enough to point this person to a good line of, to direct this person that, oh, do it this way. Do it this way. No, you shouldn't have done it that way. Do it this way. Instead, we started screenshotting, we started speculating, they started, the employee and, was in trouble. The friend who was trying to get help was in trouble. Friendship ruined. A lot of things happened because one person started with not being digitally decent enough or responsible enough to know that when you're sharing information, you don't share details that could incriminate the person that you're trying to help. I put it here. When does helping cross into harming? And how safe are we, even among our own friends and colleagues? Being HR doesn't exempt us from discretion. It demands more of it. Asking for help is not wrong, but it must be done without exposing identities or breaching trust. And if you ever screenshot a colleague's post, ask yourself, am I protecting or punishing this person with this action? If this was done to me, will I be happy? Now, this screenshot that I have just done now, that I am about to send to another person, what exactly is the trouble that it can bring to this person? What situation will this person be in the nearest future or immediately I send this screenshot out? Put the person in your shoes. If you are the one, would you be happy that someone, yes, you were not digitally decent enough to know that you're supposed to not expose identity? Now you have made the mistake and someone had capitalized on the mistake because the person wants to carry rumor. My friend, hey, if you see what they are saying in the group about your organization, let me go and screenshot it. You see, now I'm coming. And then quickly go and screenshot. Pam, send it. So these are the case studies that I brought together for us to, to relate to the whole thing that we're talking about as regards digital responsibility. There are common HR violations and excuses, which I've already mentioned, it's just HR people here. I didn't think it would matter. I was only trying to help. It's not that serious. You are just being too serious. Calm down now. It's not that serious. Calm down. It's your person now. is your friend. This person has helped you before, you not remember. You know, can you remember I sent one document to you last week? I'm there. It's me. Oh, you shouldn't have reacted this way. Oh, just because I posted something one small thing. All of these are dangerous excuses that we use to trivialize digital irresponsibility that we need to stop. And of course, there are issues, there are common violations that we HR ourselves are guilty of. You know, we use policy as excuses to harm employees. You know, it's in our policy to do this. Or we totally just go, denial or discrimination or wage theft or harassment. All of these things are some common HR violations that also surrounds digital responsibility that we also need to work on as HRs. You cannot protect employees' data at work and then recklessly share it outside work. It defeats your professional credibility. And so this is where I will quickly just mention some toolkits that I've, of course, as usual, whenever I have a webinar, I will usually share some toolkits that could also help you to action this topic in your workplace. So I've prepared some toolkits which are here, and I also have a separate document on this toolkit. If you're interested, you can reach out to me and I'll share the documents with you. Acceptable use policy. That's a policy that you can implement in your, draft and implement in your workplace that sets standard for digital tool usage, prohibiting unauthorized sharing and reputational damaging posts, digital responsibility code. What do we do here? How do we do it? Respecting boundaries and all of that. How do we undo digital misconduct? The step-by-step protocol from complaint to disciplinary action and including documentation and retraining. It should not be when an employee had put your organization in a bad light out there. Then you are now start looking for a policy in your handbook that helps you in the proper, punishment or the proper way to go about this. And then you start looking for it. There's nothing in our policy that say that tells us what to do. And then you now start dishing out punishment like an idiot on your own without any policy that is supporting this. No. There's supposed to be a step-by-step way to undo digital misconduct, and it's supposed to be in your policy. So if you don't have it in your policy, you have some work to do. Your WhatsApp group rules. Do you have WhatsApp group rules that binds your organization? What should be shared? What should not be shared? What people should take out of the group and what must remain in the group. Some suggested responses and templates that you can use to inquire from staff members or colleagues if they sought consent from the person before they share whatever it is they've shared. And whatever consent you have shared, one thing you should know is that, for example, sharing contact details in an open group, no matter what, even if you have sought consent from the person, is still is still against the law. You should not do it as a citizen now, not even just a professional alone. So all of these things, you need to know that, and you need to probably have a template that guides you on how to properly communicate when you are trying to, inquire about what they need to do. Simple clauses in your handbook that can support and help you guide against digital misconduct. And of course, the last but not the least, audit. At every point in time, you need to do wellness audits to ensure, just to checkmate your processes, your digital processes, your digital toolkits. Are we digitally safe and sane? Are we misaligned with our policies, our digital, our policies, our digital toolkit, or our AUP? And there are sample questions that I put together in the document that I prepared, that talks about the digital boundaries, the awareness of misconduct, and how to checkmate if we are still safe and sane. So now I'm going to go back to my colleague, who is going to now tell us all of these bala blue that I have just talked about. What is the law saying about it? Is this just from my head, or is there a law that actually is saying, yes, this is wrong? Over to you, Miriam. Thank you very much for having me.
Thank you, Ma. So HR has spoken about, my colleague has spoken about okay, I think you should stop sharing your screen so I can share me. Okay. So HR has shared the implications with us, and she has also given a lot of real life scenarios, and in addition to the ones we also mentioned earlier. So now we'll just immediately proceed to the core legal framework. Please, can everybody hear me and see my screen?
Yes, we can.
Okay, thank you. The first legal framework we'll look at is the Cybercrime Prohibition Prevention Act. And we already mentioned earlier that it majorly governs technology crime, any crime you are committing on the cyberspace. The cybercrime has something for you. So again, we'll look at the Nigeria Data Protection Act of 2023, which governs how personal data should be collected, stored, and processed. So the Cybercrime Act, as it criminalizes a lot. When we say cybercrime, so anything I say under here is a crime. The punishment is either imprisonment or fine, or imprisonment and fine. So some of the we just had to highlight some sections out of it that talks to workplace cybercrimes. So one of them is Section 6, which provides that employees must not access systems or files without authorization, even if technically possible. So even if it's that, okay, you can always access this thing, the person that has the data, do you have the consent of the person? Do you have the authorization of your firm to, of your company or your firm to have access to this? So you must look at it. And if you don't, then the Section 6 provides for the punishment of that action. Another one is system interference. Basically means that when you are tampering with servers or deleting critical files, I mean, it might not be critical to you, it might be critical to the firm, critical files or disabling security measures. So Section 8 of the Cybercrimes Act prohibits this action. Another one is cyber stalking or harassment. For example, one of the examples my colleague gave earlier, that she said that she only asks for, more like when someone asks you for something, then keep on sharing the person's number to people, then they start harassing with text messages and calls, is actually prohibited legally under Section 24. And of course, it will be traced down to the person that gave the number from the beginning. So it says that digital harassment, threats, because harassment is subjective, even though it's so what you might see as harassment, threats, or offensive content via work channels, not even your personal channel alone, is a criminal offense. Section 24 of Cybercrimes Act criminalizes this. The next one is identity theft and impersonation. Earlier, I explained that identity theft is when somebody takes your identity, more like misrepresentation, impersonation rather. When somebody takes your identity, the person majorly acts like you. and for maybe favors or maybe to commit a crime. So Section 22 criminalizes this and says that anyone using somebody else's credential, because I might just be at home myself. It's not like I'm wearing your skin, but I'm wearing your skin. I'm wearing your skin is in the sense that whoever I'm chatting with over the phone thinks that you are me. So and this is also punishable under the Cybercrime Act. And even all this cybercrime, the thing with our crime in Nigeria is that at times it's not even centralized. Now that the Cybercrime Act prohibits it, I can assure you that there are other laws, that there are other punishment under it, and the prosecutor will always determine, might always determine which acts that he wants to prosecute you on. So you might think, oh, it's just cybercrime, it's just a cybercrime, but then they'll just extend it to fraud, extend it to lots of things. And another one under the Cybercrime Act is electronic information misuse. More like we already have your information electronically, and we can always use it without asking for consent, or we can always use it for whatever we want. So the Cybercrimes Act provides for different prohibitions on electronic information use, especially in banks. So let's talk about Section 37 sub 1, which says that a financial institution shall verify its customers if its customers wants to involve in electronic finance, more like fintech. So we already have your details. For example, I'm a bank. We already have your details. You've been coming in and out for your banking procedures, but suddenly you said you need electronic banking. So we will need your information before you proceed with the electronic banking. For example, ATM cards. ATM cards, of course, is electronic. Even fintech, I mean, our phones, the banking apps that we use. So anytime you want to use a banking app, first let's talk about ATM cards. So banks will not just hand over ATM cards to you. They will ask you for information like your name, your bank accounts, and all of those related questions. To you, they are just asking questions that they already have at their disposal. But to them, they are asking you questions that they are meant to ask you based on the law. I mean, yes, we know that we have these details, but let's be sure that you are the one asking for this thing, or let's be sure that you really know what you're doing. So they will not just hand you card, and that's I'm sure that we can all relate to it. It happens in practice. And another one is Section 37 sub 2, where the Cybercrimes Act provides that any officer of a banking or financial institution that proceeds to carry out an electronic instruction will be punished. So let me just break it down. For example, so there's this at times you can call your accounting manager to do this and do that, but then you just notice that they're asking you questions to verify. This is just a way to avoid something like phishing. We already said earlier, excuse me, that phishing is voice phishing. So you might not be the one, so you might not necessarily be the one asking. And that's why they're asking you for those questions, to be sure that you really know what you are doing, or to be sure that you are even the one asking for that to be conducted. So I remember that there was a time, and even on our banking apps, you just notice that, okay, maybe they're trying to get your information, and they have already reduced this thing into PIN. I mean, for the first one we talked about, that when you're trying to carry out financial institution, when you're trying to carry out electronic financial institution, you notice that every time you log into your banking apps or your ATM cards, they ask for your PIN. Most of us just think it's just a procedure, but it's just personal identification number, which implies that this thing is unique to you and it can be only used by you. All those things are things that banks put in place to be sure that they are regulated, that they are following the regulation. But we just think it's procedure to only secure us, but it's also securing them and their identity. So the next one is this one that we're talking about now, which is on electronic information So the Section 37 sub 2 of Cyber Crimes Act prohibits any official or organization who obtain proper identity of customers before executing unique instructions in whatever way. So it places a fine on it. I remember there was a time I was shown online, I mean, on my bank app. It was in the middle of the night, and I just noticed that my network is bad. Hello.
We can hear you.
Oh, thank you very much. So there was a time I was trying to carry out a transaction in the middle of the night, and I just noticed that the banking app started asking me to scan my face. I was surprised, I was shocked, but then I just knew that, oh, it was part of the procedure. And at times, you even try to carry out some transactions in the middle of the night. You might think that, why am I carrying out a transaction in the middle of the night? But I was trying to like carry out a transaction, and it didn't even go at all. Although you might think that, oh, that's kind of security being put in place has its own disadvantages. Well, I bet you that its pros outweighs the cons. So some transactions might actually some transaction can wait till the next day. And another provision under the Cybercrime Act is the one that provides that any official or organization who fails to obtain, okay, I think we've done that. So the Section 29 of Cybercrimes Act treats forgery or illegal use of customer security code as a crime. So it gives them punishment, imprisonment. I think it's 5 years imprisonment, or 5 million naira, or 5 years imprisonment and 5 million. It could be both. And basically, any crime you commit online, most of them are actually 5 million. So at times, the financial implication on the owner of that data itself might be more than 5 million, but then at times our laws might not be as we want them to be. And in some cases, we have forfeiture as well. In most cases, actually, we have forfeiture where you return what you get. So moving on to the Data Protection Act, which is basic, more like it's a well-encompassing law on protecting the data of everybody. So the Data Protection Act is Section 24, provides that data must be processed in a fair, lawful, transparent manner. So this one is, I think we should just like pay more attention. So it says that any data that you are processing, because most times we deal with data. I mean, most times HR personnel, you guys deal with a lot of data. So if you are collecting data, you're not just collecting data. The less data you collect, the less data you have to manage. You should not just ask for everything, ask for the person's the time the person was born, when all you need is just the date of birth. So the less data we collect, the less data we manage. So this Section 24 that provides that data must be processed in a fair, lawful, transparent manner. It aligns with global standards of Singapore Personal Data Protection Act, the UAE Federal Decree number 45 of 2021, the India IT Act, the EU General Data Protection Regulation, and the likes of it. So all of them, they actually just stress on informed consent. What is informed consent? Informed consent can actually be, I wanted to explain like in medical line, but let's just leave that. So informed consent is basically that, okay, the initial thing is there's consent, there's informed consent. Consent means that you are getting this person's consent, but informed consent is that this person knows why you are getting this consent. This person gave that consent being informed of what you need the consent for. So it's basically saying that whoever you are getting consent from has a the total details. The person is giving you the consent, knowing what you need, the what you want to use it for, and the implication at the end of the day. Because you might get some consent, let me take your pen. Yes, take my pen. But informed consent means, can I take your pen for this and that? I'll return it this and that. I might return it broken. So that is what informed consent is. And under all this global standard is also where we have data minimization, or where we already explained that the less data you collect, the less data you have to protect. Data minimization
Hi,
is that just
Miriam.
collect what you need. Don't collect more than you need. Ma'am?
Okay, I just want to quickly ask a question here so that my colleagues here can understand very well what you're saying, because I realize that what you just mentioned regarding consent and informed consent is very important to our jobs, because sometimes we think that we have actually seek consent from employees, whereas we have not actually sought their informed consent. And so if
Yeah.
they take us to court, right? And
Yes.
the court asks them if their consent was sought. It means that they could say, yes, HR asked me, but HR did not explain to me what he is using my data for. And
Exactly.
so our organization is still liable, right? Despite the fact that
Yes.
we
Yes.
asked these people for this information and we sought their consent, right? But because they
Yes.
did not know what we were using it for, and so they've taken us to court, and so they've sued us, and it means that we are now liable and we are going to pay, right?
Yes, you are very correct.
Okay.
It means that
Thank you.
you might. So consent is basically not just about ticking box. Consent is about knowing what you're taking. Consent is about informed consent is about putting out why this person is ticking this box. You're not just getting the consent for consent's sake. You're getting consent because this person knows consequences and implication of giving that consent. And there's transparency as well. Transparency simply means straightforward, and that is it. So, more like from all these global regulations, the core principle that reflects from all these foreign laws is that digital responsibility, when you're collecting data, includes they are collecting lawful data. You are being fair, being transparent. The data you're collecting is purpose limitation. It still boils down to data minimization, the accurate data, then store data for. I will still like bring examples. I'm just trying to give you the core principles. So storage limitation, integrity or confidentiality, as well as accountability. So under these laws, it's just basically saying that organizations must clearly disclose why data is being collected, how long it will be stored for within their organization. Even if they're going to transfer it, they will tell you. And so consent should not be seen as a formality. It has to be informed, and it has to be voluntary and unambiguous. So now I'll take us through some examples that can serve as formats when we are seeking consent. So you will know that these examples are basically, so they comply with these laws that we've talked about. So I'll read it out. For the first example is, let's say a law firm. Is it this one? Yeah. So a law firm outlines its client's data collection and protection practices in a service engagement. This is basically saying that somebody is bringing a job to a law firm. So the law firm is telling them that, oh, we'll take this, we'll take that for this service that you're asking for. Maybe while filling maybe a service level engagement agreement, it could be a cluster, or maybe it could be oral. No, most times it's even better to be written. So let's not always make that mistake. where someone gives you an oral assurance written one, let it be in writing so it can be permanent. Whatever is written cannot be disputed, even though at times it can be, but then it's so example one says we collect only the minimum personal data necessary to provide information and relevant case documents. And we do so with your explicit consent. So you're already pinning the person that this thing that we're going to take later is with your consent. So if you consent under all these things, we are taking it with your consent, with your explicit consent. Your information will be processed solely for the purposes disclosed to you. So we are not going to use it for anything else. Stored securely and retained only for as long as required by law or our engagement. Let's say our engagement, what the job the person brought to your law firm was just a 1 week thing. Why are you keeping his information for a year? So, and for our engagement, we do not sell, share, or use your data for unrelated purposes, and you may request access, correction, or deletion at any time. By engaging our services, you acknowledge that you understand how your data will be handled in line with our data protection policy, reflecting our commitment to digital responsibility, client trust, and legal compliance. So this is already telling the client that you are not the one to decide. I mean, the client is not sent to us taking it, then you cannot just come up later and tell us that we should have not taken that information. So it's just basically being transparent with the person, telling data minimization. I think it's already covers. So the next example is for this one is more like an internal informed consent. So a law firm introduces or launches a new secure remote. Oh, I think we already, did I miss it? Okay. So the next one is a law firm introduces a new secure remote access system to allow lawyers to work from home. So this is, we already have, we already said it earlier that innovation has come to stay, digital workspaces put in place. So the law firm to allow lawyers to work from home while protecting clients' confidentiality. So what the law firm can tell or no, can send to its employees to just to understand what's going on. So say we will collect only your firm issued email address. Firm issued email address, encrypted password, and work device identification number to enable secure two-factor authentication for remote access. This data will be used solely for identity verification, stored in encrypted form on secure servers in Lagos. So that's location, because even location as even this data protection could be location based. So we'll still get there later that when the data of your clients cross borders, what do you do? So in Lagos, and deleted within 30 days of your exit from the firm. We will not access your personal browsing history, personal apps, unrelated biometric data, or personal files. Access is limited to the IT security team, and system logs will be reviewed only in cases of suspected unauthorized access. By continuing, you confirm that you understand and consent to this process in line with the firm's data protection policy. So this is basically if we are following, you will understand that this is basically to protect the client's data from third parties. So you might be working from home and your husband is looking at your laptop. So when your husband is looking at your laptop, or maybe you move a particular file from your system to another place. especially through your firm's email address. So when the firm suspects that that kind of thing has happened, then they will look at it to investigate. That's when they suspect unauthorized access. I mean, there's the firm system. Why are you moving the firm's file out of the firm system or out of the firm's email address? So this is basically telling them that you are working from home, but then we are watching you. And this is what we are using to watch you. We are using your email address. We are taking your email address, your password, and any authentication that you've done based on this email address. We have them. The IT department has it, which is also talking about I don't know if we mentioned it earlier that only the persons that is actually working with the data should be entitled to see the data, should have access to the data. So even if, for example, let's say a law firm has a client and we have the personal data of this client, but then the ICT department took maybe made copies of some of the personal data home. Why does the IT department need it when it's just the lawyers and probably the secretariat team, the admin that should have access to it? So if anything happens at the ICT guy's house, more like exposing the client's data, that's already out of the way. So the clients that gave consent earlier did not give consent that the ICT guy should take it home. So all those things, even where he gave consent, so that's already leaving the line of consent, and you could actually make a case out of it. So, and the next one is, this one is internal. This one is, for example, company launches an employee. All this is just giving us example of what informed consent should look like. How you can couch any clause that shows that any data you're taking from your client or customer aligns with global standard, which shows data minimization, data storage, data access, and excuse me. So it says that this, for example, now this company is trying to launch a wellness program for its employees. So, and I think it's meant to be free and annual. So the example of what the company can tell is that we will collect your cholesterol level and BMI, body mass index, during the wellness check. These results will only be used to assess your eligibility for our wellness rewards and will not affect your employment status. Being transparent. Participation is voluntary. Your data will be stored securely for 12 months, after which it will be deleted. Access will be restricted to the HR wellness coordinator and the contracted healthcare provider. Aggregated anonymized statistics. So we are still protecting you. So this paragraph is just saying that we are not going to know what is wrong with you per se. We are just going to know, okay, so portion, or more like statistics based, so portion of our employees are suffering from this. How do we enable good health within the organization? So aggregated anonymized statistics may be shared with the management to evaluate program effectiveness. So these examples are just showing what informed consent, data minimization, transparency, fairness, lawfulness, data storage looks like globally. So the companies only have the relevant data that is needed and is transparent. So now that we've seen this, I think we can proceed to how we can embed digital responsibility into our internal compliance strategy. So is important that organizations adopt a code of conduct or a code of ethics, because our background differs. What I think is wrong might not be what you think is wrong. So our orientation is very, very different. But when a firm or a company has its own code of conduct. I mean, a robust one, not just one on the surface level. It helps the employees to act in line. So a clearly written ethical standard harmonizes expectations and reinforces professional responsibility. So you might have expectation of something from somebody, but that person does not even know that it's meant to do it. But where it's written, where you already have it ethically, then the person knows that this is what he should do. So from our own perspective, I mean, the HR has spoken about from HR's perspective. So where you are trying to internalize compliance, when you're trying to internalize digital responsibility into your workspace, what do? You create a robust data governance framework. And this framework should include that anytime you are doing anything, your for example, maybe staff handbook to show that when obtaining informed consent before data collection, you inform your staff that anything you are doing, obtain this, obtain that. The second one is limiting data access to staff with a legitimate need. I think we already explained that as well. The third one is ensuring transparency in data use. I'm sure that those examples that we said earlier, I'm sure that now that we are listing these things, would be reflecting on them, understanding better. So collecting data only when necessary. So we are only collecting data when it's necessary, and we're only collecting data that is necessary. You don't need my time of birth when you get my date of birth or my place of birth. So where there is remote work access, you should try to find a way to include personal data strategies that works internationally across borders. So put in place adequate safeguards that extends across borders. So most times it's best to follow global standard. The next one is implementing strong cybersecurity measures. So you reach out to professionals that, okay, how do we do this? How do we do that? Apart from two-factor authentication, what else can we do to secure data? And the next one is can I say this clearly? The next one is ensure workplace practices are consistent with the provisions of the staff handbook and the laws of the federation. Yes, and the laws of the federation. The next one is operators must remain accountable for AI decisions. So we already talked about the fact that there is a lot of innovation and we've been using a lot of AI tools, more like when we talked about recruitment, using algorithms to grade participants. So be sure that these AI tools are in line with what you need. And so anytime anything goes wrong due to the algorithm results, the operator that will be at fault. You cannot blame software. So you know how to put that in place as well. Then the next one is ensuring compliance with both sector specific regulations, like maybe Consumer Protection Act and general legal frameworks like the Data Protection Act and even the Employment Act for internal regulations. Then monitoring and surveillance. I think this one is like to the extreme, but we could do it with lawful boundaries. So, because in fact, Singapore CDPA that we mentioned earlier that aligns with global standard really supports monitoring and surveillance. And how can we monitor and survey our employee or data protection in the system? We could use CCTV, we could use emails, we could use IT logs, that's maybe your browser. So that's what I'm saying, that is very, very used to the extreme, etc. and things like that. But then because we could just keep these ones to maybe during investigation. So apart from all this one that is above, what other organization habits what other organization habits can promote digital responsibility? So habits that can promote digital responsibility is one, let's align our digital identity, which I already said that your digital identity is your footprint, is actually who you are outside the world. So the workplace should ensure that staff posts minimal things. You minimize how you post about your workplace, because when you're talking too much, you already say, when you're talking too much, you won't know when you say too much. So you will ensure that your staff do not post sensitive office content online. In the realm of doing content creation, are you looking at these videos properly? Are you looking at the write-up properly? Is any client data out there? Is anything that you are not meant to show to the world? Is it in the background of your video and things like that? So the next one is to enforce strict social media policies. For example, when you're maybe posting a picture, you could maybe not expose your ID PIN, because there are some companies that you use PIN to go in. So, but where an employee is already exposing that out, anybody could come in, identity theft. So the next one is that we conduct regular compliance reviews. This means that even where a company already has compliance policies in place, are we reviewing them? Are they up to date? How often can we review them? Maybe annually. Maybe when a new law comes into place. Maybe when you get a new staff, some people need special policies. Maybe when you get a new staff, maybe when there's a new law on data, or a new law on technology, or a new law on data protection, or a new law on your particular sector, or even when a breach occurs. I recall when I was researching Yum, maybe it was Yum or Cisco, they said that they had to like revamp their security measures put in place, their compliance laws and all of that. So another one is we should try to conduct digital responsibility tests. There was this public holiday that people started posting online that their company sent phishing mails. So you could test how your employees are sensitized about digital responsibility. See if they will fall victims. You know how to train them. You know how to sensitize them about it, and you already know your weak points. You know where to target. You know where to treat. The next one is update legal policies to reflect evolving threats and responsibilities. 10 years ago, we might not be looking at creating policies on remote work. So just imagine that you are still using 10 years ago staff handbook or 10 years ago workplace policy, as at now that you're already practicing remote work. So the next one is treat data governance as a non-negotiable culture. It should be part of it. It's not just a box ticking exercise. It should be part of the frame. They should understand why it is important, and it should always be at the back of their mind, basically, at the back of the staff mind. Then another one is penalties. Then encourage multiple factor authentication. I think you already talked about that one. Then for penalties, I didn't involve it. I didn't include it here. But for penalties, which we could come up with penalties for, just inform them that there's a penalty if so happens, if so happens. But then I would just advise that the penalty does not include deducting the salary, because it is according to the Employment Act, there's nothing that should warrant an employer to deduct the salary of an employee. And even under penalty, I remember now that this our law, I mean our Nigerian law, is even like really evolving in penalizing data exposure, because two of the tax acts, the NRS and JRB acts, they provide that any of their employee that exposes taxpayers' data, or even the taxing authorities' data, will pay penalty of 5 million it was previously 200,000, but now it's 5 million. For us to know how data protection is important. If governments can place 5 million on just exposing somebody's data, even in taxpayer data or even government data, then we should know how to internalize it in our own as well. So, and the next one is, yeah, we are coming to the end. The next one is HR and legal. How can we align everything that HR has said now and what I've said? How can we align it into our workplace to increase our digital responsibility? The first one is policy development and implementation. We've been explaining it's more like a recap. So this is just saying that legal insights provide the framework, more like your legal department or your legal perspective. They provide the framework for developing workplace policies that align with statutory requirements, such as those governing data protection or anti-harassment laws. So what does the HR do? The HR communicates clearly this framework, communicate clearly and integrate it into daily operations. For example, if the legal department drafts a privacy policy, more like privacy, okay, confidential, non-disclosure, and all of that, the HR ensures that employees receive and understand it. And even when they are bringing new persons in, during onboarding, that person receives and understands it as well. The next one is, how do you manage workplace misconduct? So basically, the legal department determines whether the behavior violates employment law or regulatory obligations. Maybe the behavior is an harassment or not. So so when they determine, the HR oversees the investigation and like just carry on from there. For example, HR will say something about posting online. If an employee posts an offensive content about a colleague online, the legal team will assess if that content is harassment, if it's harassing the other employee, and the HR manages the process, the interview process, the investigation process, and the HR applies the company's disciplinary procedures in this situation. The next one is remote work and jurisdictional issues. How will the legal team help with remote work and jurisdictional issues for digital responsibility? So the legal team advises on labor law, tax obligations, and cross-border regulations. More like somebody is working remotely, but the person is maybe working from abroad. You employ this person because the person is an expert. How are you still going to protect the data of your clients when it's moving abroad to an expert? So when the legal department checks the tax obligation, labor laws, or data protection laws across border, the HR then adjusts the contract, because for every company you have a template for contracts. You have a template contract for every person you bring in. So the HR adjusts the contracts, the benefits and workflows. For example, if you're hiring anybody from another place, the HR is going to look at it, tell the person that this is how our data protection is in this country. And it's best advised that when you are moving your client's data abroad, the Nigeria Data Protection Act provides that any part of the world that you're moving a data out of Nigeria, that particular place must equivalent data policy standard with Nigeria, or even better than Nigeria. So the legal department looks at that. Is it better? Should it be adjusted? And the HR implements that. And the next one is digital monitoring and employee privacy. So as I said, the monitoring is like to the extreme, because you won't know, you might think, your employee might think that you don't have access to his browsing history, especially because you already stated it in the consent form, or you have access to the browsing history. So legal guidance outlines acceptable practices for monitoring employee activities. Then the HR determines how to implement such measures. For example, if there is a tax productivity software, the legal professionals will see maybe this software limits, we look at the limits of the lawful surveillance. Then the HR will inform the staff that, oh, there's this software in your system now, and the HR obtains the consent of the staff. You might think that, why do you need consent of your staff? You need consent. Just, I mean, all these things are just things that the law puts in place. And where your employee now decides that he doesn't want to give consent, then you know that speaks to his work policy, and then you know what to do. Then the next one is AI and employment practices. We already talked about it. You have to take responsibility for whatever AI generates for you. And the how we can actually look at it now is that the legal departments can check all these AI tools if they have discriminatory, even for anti-discriminatory policies, because at times algorithms can be wrong. Maybe in your workplace, all the persons that have been working in a particular department they are trying to recruit, is all of them are males, but then you now put in a CV of somebody that is a female, then the AI rejects it. So the legal department looks at this AI tool for any anti-discrimination laws. Then the HR selects the one that is best. For example, if a company is using AI to screen job applications, so you just have to pick the one without the anti-discrimination laws. And I think we've covered it all. And so we'll conclude. I would just like to leave us with the fact that digital responsibility is not just, it goes beyond using the right tools. I mean, yes, we owe our clients responsibility to do their job well, but then again, we also have to understand that what we are doing, is it against the law? Is it even against the client's rights? Are we being transparent with them and all of that? So the legal department builds the framework, the HR shapes the culture and all of that. So when HR, legal and HR, if we work in unison, then digital practices will align seamlessly with the law. I mean, your company digital practices will align seamlessly with the law and your workplace value, even your client's value. Then it creates a culture where compliance and transparency are second nature. More like it's just part of us. It's not that you now finish what you're doing, then think about it later that, oh, I should have done this, I should have done that. And where we just align with everything that we've talked today, is just going to move us beyond the screen, and it's going to allow us build a workplace where every decision we take, every keyboard we click, every mouse we click, and every interaction between us, between the legal departments, the HR, the IT departments, the clients, the company, the employer, just shows responsibility and readiness for the future, because digital innovations and all this digital thing they are just here to stay, and they will always grow with us. And that's the end of my presentation. If we have any
Thank you
questions,
very
and
much.
I'll just leave it to HR because I'm sure she still has things to say.
Oh, thank you. I think I am done really. Thank you very much, Miriam. That was very insightful. Thank you so much. I think I just picked two things from what you said. I picked the employees' health part where you mentioned that even when you've sought their consent to take their BMI and some health information about them, you should only use those health records for only what you told them you were going to use it for. For example, if you've told them that you're not going to use it against their employment or whatever, you just want to take their BMI and know their current health record, and then you collect it, and then you are now gathering, and you now know that maybe an employee is HIV positive, and then you are now probably there's now rumor going up and down in the office that do you know that this so person has HIV, or do you know that so person recently aborted, and information is going up and down. Then you've breached the employee's privacy, and even though you sought the consent of that employee can still sue you, because the consent you sought was not what you used the information for. And I also picked something from what you said, which also aligned with one of the things we discussed today at one of our groups, which talking about for how long can you keep the data of an employee even after the employee had left the organization. In fact, it was like you were in our group when we were talking about this thing today. We're still talking about this thing today. It was actually an eye-opener to know that some people, some HRs actually need to, some of us still needs to know that, some of us need to know that there's actually a timeline to when you can keep employees' record after they must have left. And so after they must have left, even when you want to keep some record for probably reference purposes, there are some information that you cannot keep. For example, I think the law gave 6 years or so, between kind of 6 years duration as active file, as when you can keep the active files. After that duration, you can then archive or dispose. When you are archiving, there are some information that you have to take away before you can even archive. For example, you have no reason to keep the health record, or probably the health or whatever pregnancy test, for example, that an employee did when he was in your organization in probably 6 years ago, 7 years ago, 10 years ago. You probably just archive everything. It's probably a physical file or an online folder. You probably just put everything in your archive. If the the organization that comes to check if we actually data compliance comes, and they see that there are some informations that boils down on health record of the employee, or something that is very personal about the employee, that the employee has left your organization 6-7 years and you're still keeping it, you can be sanctioned, and there are now high penalties about it. So I picked that which you mentioned, and I think that's where I just want to probably conclude and state that as HRs, I think we still have a lot of research to do when it comes to data compliance, data policies, what we should keep, what we should not keep, consent to seek, how we should seek consent, and how to, especially what to do when it comes to generally data. Thank you very much. And I will leave this for the floor for Dr. Oluyemi, and probably if there's any question. If there's no question, we probably just round up. Thank you very much for listening to us.
Thank you so much, Miriam and Victoria. This has been insightful. On behalf of all of us, no question. This has been robust. This has been complete. This has been thorough. Ladies and gentlemen, let's unmute and let's thank our facilitators for tonight.
Thank you, guys.
Thank you, our facilitator.
Thank you so much,
our facilitators.
Thank you very much.
Amen.
This is
Thank you very much.
highly
Thank you.
insightful.
Thank you very much.
Highly insightful.
Thank you. Thank you so much.
Thank you, everyone.